The U.S. Supreme Court decided in a 5-4 vote Tuesday to refuse to let Americans challenge the eavesdropping law. The Foreign Intelligence Surveillance Act, or FISA, was originally passed to allow spying on other countries' communications, but RT reports the act was greatly expanded in 2008. Under the FISA Amendments Act of 2008, FAA, the NSA is allowed to conduct electronic surveillance on any U.S. citizen as long as they are suspected of conversing with any person located outside of the United States. A lawsuit by several organizations, including Amnesty International, says the act lets the government use dragnet surveillance, monitoring all kinds of communications without having to prove any national security interest to a judge. WLWT reports
the suit was filed by a group of lawyers, journalists, and activists who were concerned that the government could eavesdrop on communications with clients and sources.
Instead of hearing the case, the Supreme Court dismissed the claims that the plaintiffs were being watched, saying they had no standing because none of them had been actually harmed by the policy. USA Today quotes Justice Samuel Alito saying, "This theory of future injury is too speculative." He said it was hypothetical future harm. The decision has privacy advocates like The Guardian's Glenn Greenwald fuming. He says the government's post-9/11 surveillance programs essentially sidestep the U.S. Constitution. As both the Bush and Obama administrations have repeatedly proven, they are free to violate the Constitution at will, just so long as they do so with enough secrecy to convince subservient federal courts to bar everyone from challenging their conduct. Or as a writer for Ars Technica sums it up, one by one, the legal challenges to expanded government spying in the post-9/11 era are failing in court. But a lawyer for the ACLU isn't surprised at the ruling, telling the New York Times there has never been a serious challenge to any of the government's most controversial security policies. More than a decade after 9/11, we still have no judicial ruling on the lawfulness of torture, or extraordinary rendition, or targeted killings, or the warrantless wiretapping program. These programs were all contested in the public sphere, but they have not been contested in the courts. 4 judges dissented in the opinion, saying the court has found standing in cases where the future harm was far less likely than in this case. For Newsy, I'm Bryce Sander.